Taxable Instruments class, I have made 3 case digests regarding warehouse receipt law or the Republic Act 2137. And the first case is Philippine National Bank versus Atendido. Here is the facts of the case. Atendido obtained from PNB a loan of 3,000 pesos, payable in 120 days with interest at 6% per annum from the date of maturity, and pledged 2,000 kavans of palay to guarantee payment, which were then deposited in the warehouse of Cheng Xionglam and Company, and to that effect, the borrower endorsed in favor of PNB the corresponding warehouse receipt. Before the maturity of the loan, the 2,000 kavans of palay disappeared for unknown reasons in the warehouse. When the loan matured, Atendido failed to pay both the principal and interest. Atendido claimed that the loss or disappearance of the warehouse receipt covering the palay which was given as security having been endorsed in blank in favor of the bank consequently relieved him of liability. The issue of the case is whether or not the surrender of the warehouse receipt covering the 2,000 kavans of palay given as a security endorsed in blank to PNB has the effect of transferring their title or ownership to PNB. The ruling of the court is no. The Supreme Court upheld the findings of the lower court that the surrendering of warehouse receipt number S1719 covering the 2,000 kavans of palay by Atendido in favor of the PNB was not that of a final transfer of the warehouse receipt, but merely as a guarantee to the fulfillment of the original obligation of 3,000 pesos. It was given as a collateral security. Hence, PNB had no right to dispose of the warehouse receipt until after the maturity of the promissory note. Its ownership remains to the pledger, subject only to foreclose in case of non-fulfillment of the obligation. Moreover, the endorsement in blank to the bank of the warehouse receipt covering the palay was delivered does not alter the situation. The purpose of the endorsement is to transfer the juridical possession of the property to the pledgee to forestall any possible disposition thereof on the part of the pledger. This is true notwithstanding the provisions to the contrary of the warehouse receipt law. The Supreme Court held that where a warehouse receipt or cadan is transferred or endorsed to a creditor only to secure the payment of a loan or debt, the transferee or endorsee does not automatically become the owner of the goods covered by the warehouse receipt or cadan, but he merely retains the right to keep and with the consent of the owner to sell them so as to satisfy the obligation from the proceeds of the sale. This for the simple reason that the transaction involved is not a sale but only a mortgage or pledge, and that if the property covered by the cadence or warehouse receipts is lost without the fault or negligence of the mortgagee or pledgee, or the transferee or endorsee of the warehouse receipt or cadan, then said goods are to be regarded as lost on account of the real owner, mortgagor or pledger. Wherefore, the decision appealed from is affirmed with costs against the appellant, Atendido.